Hi everyone. The topic of my presentation is Director of an Australian company. First of all, introduction. A director of a new company registration has a wide range of important duties after setting up a company, and as such it is important to that newly appointed director is aware of them. This presentation highlights the duties involved for new directors and also gives advice as to how to avoid being in breach of these duties. Director definition. A director is a person from a group of managers who leads or supervises a particular area of a company program or project. Only an individual can be appointed as a director. A company director does not have to be a stockholder or an employee of the firm. Meaning, an appointed or elected member of the board of a director of a company who with other director has the responsibility of determining and implementing the company policy according to section 2-30 provides that no body corporate association or a firm can be appointed as a director of a company. Next topic is qualification and disqualification of a director. First of all, disqualification. As an insolvent person cannot become a director, an unsound mind person cannot become a director. A person has not paid any call in respect of shares of the company. A person who have been convicted an offense or declared by a court. These are the disqualification for the directors. Next are the qualification for the directors. A director must hold a share in the company. Each director must take his qualification share in within 2 months. Power of director. Power of directors are power to buy back its shares, power to issue debentures, power to borrow money from other company or from RBI, power of power to invest funds for a company, power to make loans, power to fill the casual vacant seats in the board, power to make political contribution, power to recommend on and the rate of dividend in the annual general meeting, power to appoint any person or manager or general manager, power to interfere. These are the powers of directors. Next are the general duties of the directors. First of all, common laws to act in good faith, to act in the best interest of a company, to act for a proper purpose, to give adequate consideration, to not fetter discretion, and to avoid conflict of interest. Under Corporation Act, these are the duties under Corporation Act. To act with the care and diligence of a reasonable person, to act in good faith for proper purpose, to disclose any material personal interest, to not improperly use position, to not improperly use information, to prevent insolvent trading and duties around financial reporting and disclosure. Other status may impose personal liability or on directors, no notably laws governing tax competitions, occupational health and safety and protection of the environment. Duty to exercise independent judgment. A director will not breach this duty if they broadly this means that the director cannot allow other to influence their decisions or to make decisions for them. A director will not breach this duty if they act in accordance with the agreement entered into by the newly set up company which restrict the exercise of director's discretion, act in a way authorized by a company constitution, rely on the advice or work of other in making decisions. Duties to avoid conflict. of interest. Directors have a duty to avoid conflict of interest after they register a company where one may arise. They will need to disclose this to non-conflict directors and allow them to make the decisions regarding the relevant transaction. Further statutory duties. The following are covered in Part 2D 1 of the Corporation Act 2001 S181 good faith civil obligation, good faith director and often officers. A director or other officer of a corporation must exercise their powers and discharge their duties in good faith, the best interest of corporation and for the proper purpose. As 182 use of position civil obligation. Use of position directors, other officers and employees are directors, secretary, other officers or employees of corporation must not improperly use their position to gain an advantage for themselves or someone else or cause determinant to the corporation. As 183 use of information civil obligation. Use of information directors or other officers and employees a person who obtain information because they are have been they are or have been a director or a other officer or employee of a corporation must not improperly use that information or gain an advantage for themselves on or someone else or cause determinant to the corporation. Australian Securities and Investment Commission Wizard TM 2005 FCS. Section 184 Good faith use of position and use of information criminal offense. Good faith directors and other officers. A director or other officer of a corporation commits an offense if they are reckless or they are intentionally dishonest and fail to exercise their powers and discharge their duties in faith, in good faith, in the best interest of a corporation or for purpose. Use of position directors other officers. Division 2 of the Corporation Act, that the act given in the previous slide. A director or other officers or employee of a corporation commit an offense if they use their position dishonestly with the intention of directly or indirectly gaining an advantage for themselves or someone else or causing determinant to the corporation or recklessly as to whether they whether the use may result in themselves or someone else directly or indirectly gaining an advantage or in causing determinant to the corporation. Other relevant provisions of the Act Division 2 for the Corporation Act 2001 provides section number 191 material personal interest director duty to disclose. A director needs to give notice to the company of a personal interest when a conflict of interest arises unless expected under 191. Section 192 give the direct director may give other directors standing notice about an existing conflict. Directors can give a preemptive notice of a material conflict. Section 194 voting and completion of transactions of directors of a proper priority companies or director of a Proprietary company may vote once they have disclosed their material personal interest. Section 195 restriction on voting directors of public companies. Only public company directors should not be present or vote on matter in which they have a material personal interest. Section 196 ASIC power to make this declaration and clause orders. ASIC has the power to declare the material person interest in the case of company director. Thank you. Any question?